Ms. Baliela, good morning.
May it please the court, my name is Fawn Bolero, and I'm an assistant district attorney for Middlesex, appearing on behalf of the Commonwealth. Seated at the council table is Assistant District Attorney Alice Casey. Requiring Vith Lee to serve this full sentence that were imposed against him in 1990 after a jury found him guilty of kidnapping.
Yeah, and what is that sentence again? How many years?
The sentence is 2 years for the, well, it's a Concord 20, which is
2 years.
understood to be 2 years. You were paroled in 2 years back in 1990.
Maybe. Maybe.
Perhaps. Case was that back then you were.
So
And then
we begin with the premise that somebody dropped the ball in the DA's office by not immediately moving or doing whatever you have to do to when you find out a decision's affirmed in a criminal case. Correct?
I would not say that's completely correct because there's no statute or common law that vests the responsibility to do so in the district attorney's office.
Who's got the
Well,
greatest interest?
Who does it?
That is correct. It is the Commonwealth's practice as far as Middlesex District
I
Attorney's
say
Office to do
drop the
that.
ball because we're 16 years later now, and here we are.
That's correct.
So this is like adverse possession on the part of a defendant of a criminal sentence. Open, notorious, living in the public, and 16 years have gone by, and he says, you can't put me away.
And there's no obligation on him to
Surrender.
surrender.
That is correct. He was never ordered to surrender in this case following the appeals
And
court's
unless there's such an order, defendants don't have to surrender. Other states have said, you know, when your appeal fails, you've got to surrender. Ours
And was
doesn't.
he out on a personal or bail or bail?
He was out on conditions that were set by
Okay.
Justice
Personal
Brown.
recognizance with conditions, and that was never revoked.
That's correct.
Did he also appear in court 1 or 2 times in the last 16 years, apart from this most recent time?
Yes.
That's correct. He was arrested in 1999 and 2001, and he was brought to Lowell District Court for both of those cases.
And nobody picked up on it.
Well, the probation record had no indication whatsoever that these sentences had not been served, correct?
That's correct. The Board of Probation record that an ADA gets at arraignment would not indicate whether or
Yeah,
not
I
the
mean, by
sentence
then
was
he
served.
would have been most likely paroled
And paroled.
from a Concord sentence.
That's correct.
So there'd be no. So
So
what authority have you got that you can force him to go to prison at this point? Or not necessarily force him, but that the only option here is for him to go to prison.
That's correct. The general law is that once an error is discovered, that the defendant must serve his full sentence. Any departure from that law,
That's a statute?
that's a case.
What's the case?
It's cited by most of the cases in the Commonwealth's brief that that's the general rule from which you must depart.
But wouldn't you say that as of at least 2007, most courts are now on to what is the totality of circumstances and balancing various factors to determine whether or not it's going to be fair to or violate the defendant's right to fundamental fairness to impose that sentence?
I would say that they look at various tests. I wouldn't say it's always that test, the 3-factor merit test, the
No,
totality
just-
of circumstances.
Yeah, they may be different factors, but it isn't what I take it to be the old common law rule, which is you always have to serve your sentence no matter what.
That's correct. That's where they start, and then they go from there and determine whether or not perhaps they want to find that the government has waived its right to re-incarcerate the defendant, or that the government is stopped, or rather that the defendant should receive credit for his time at liberty. Those are the tests that they are.
So in this situation, you take the position it's fair to put him in the clink?
That is correct. It's the Commonwealth's position that requiring this defendant to serve the full sentence imposed against him is consistent with fundamental principles of liberty and
But
justice.
let me ask you this then, is there ever a point you'd concede after a passage of time it wouldn't be fair?
It's the Commonwealth's position that the mere length of the delay alone does not convert an inadvertent mistake into gross negligence.
So even 25 years?
That is one factor to consider in the totality of the circumstances to see whether or not it's fair. But based on the reason for the delay in this case, where it was an inadvertent mistake, where there was no statement made to the defendant by a state agent saying that, you know, you're free to go.
Baliela, can I ask you this? You're not here de novo. That's a great argument to make to the single justice. I'm reviewing the single justice's decision under somewhat different standard. Can you tell me where she abused her discretion?
The single justice abused her discretion by finding that, first of all, the right to find the defendant's sentences to be deemed served were found in the Perlman and Swope principles. Those are two separate cases. In White v. Perlman, that's a case that established due process right in serving your sentence consistent, so that so you don't have to serve it in installments. That doesn't apply to this case because it was the defendant's own motion that stayed his sentence. So, as a matter of course, he would have served it in installments. The second case, Smith v. Swope, that's where the marshal was given an order to take the defendant into custody, and there was a flagrant disobedience.
Why is it fair and just in this case to require him to go to prison now? What has occurred in the 16 years that makes this fair and just?
I would say you would have to look at all the factors. The fact that this defendant was convicted of some very serious charges, more serious than any of the other cases that have been before courts. This defendant was convicted of
His
rape and
original
kidnapping.
charges, the ones that we're here about.
The 1990 charges were very serious. The two arrests.
Except that I don't dispute that, but he got a Concord sentence. He did not get a Walpole sentence. The judge who I think released him was also the trial judge. Isn't that right?
That is correct.
Isn't that the best person to really kind of assess some of these circumstances that
You
you've been
mean
talking about?
released him, because the trial judge denied the original release. It was the appeals court judge who gave him the stay, right?
That is correct. Back in 1990, on the
but
date of
No, but
sentencing.
But Judge Zobel
Right.
decided initially that he didn't have to go back to prison, and he was
Right.
the trial judge, or didn't
Right.
have to go to prison in the first instance.
Most recently, Judge Zobel deemed the
And then it
defendant's
came up
sentences
here.
to be served. Then it came up here.
Let me pick up on something that the Chief Justice just asked you about, and I don't think it makes any difference in this case, but shouldn't we be treating the defendant's motion in this case as a Rule 30 motion for post-conviction relief?
I would say that the way that you're treating the defendant's motion is he is asserting a due process violation.
Well, he can do that in a Rule 30 motion, can't he?
He could do that in a Rule 30.
And there's a direct appeal from an allowance of that motion by the Commonwealth.
That is correct.
So you could have come up here on a direct appeal.
That is correct.
Would an alternative here be to send it back for resentencing based on this extraordinary 16-year lapse?
The Commonwealth asserts that a Rule 29A revise and revoke motion would be a mechanism that the defendant could use in order to get Judge Zobel to rewrite the sentence.
Who is still sitting, by the way.
Who is still sitting, to rewrite the sentence, to deem it, to reconfigure it consistently with his interest as he did, as he wanted, as he intended at the time.
Did this defendant spend any time in jail before he was tried?
No, he was on personal
From day
recognizance
one?
pre-trial.
No, but he did spend 2 months in jail before the stay was granted,
That's
right?
correct. On the date of sentencing, he was sent to jail 2 months before the single justice.
I take it he's in jail now?
He is in jail now, but he was convicted of failing to register as a sex offender.
Is that the reason he's in jail, or is he being held on bail on this matter?
He is in jail for that conviction, a 6-month House of Correction conviction,
Well, now,
Failing to register.
failing to register.
could he also, if we were to send it back, could he also ask for resentencing under Rule 30 for post-conviction relief, claiming that there's been too much time delay here?
The mechanism that I would see fit, if this court upholds the sentences, is to send it back to Judge Zobel to reconfigure the sentence as he intended it to be, so the defendant wouldn't be prejudiced, because now defendants aren't paroled as often as they were in 1990. So his
What if
sentence would
Judge
be consistent.
Zobel, if it went back, and Judge Zobel said, okay, I'm going to resentence. He's sentenced to time served, which was 2 months in prison before the stay was allowed by the single justice of the appeals court. Does that satisfy you?
No, that does not satisfy me, because the judge would be taking into consideration post-sentencing factors.
But you can't have it both ways.
We are seeking that
You can't have it both ways. There's a reality that 16 years have gone by, and as the judge said, he's paid his taxes, gainfully employed, paid Social Security. I mean, that's why the factors come into play.
The fact that those facts that you just cited were not under oath or submitted in an affidavit, that was part of the hearing where Judge Zobel asked.
Have you challenged his decision on that basis?
Yes.
And during these 16 years, isn't he waking up every morning and looking over his shoulder and looking at every police officer he says and saying to himself, my God, are they going to arrest me because I think I should be in prison? What about this, what I'll call, to some extent, emotional distress that he might have suffered?
That is not enough to show the defendant has been prejudiced by the 16-year delay.
And that's not even his position.
Yeah, his position is that he thought it was over.
The matters had been resolved on appeal, and he was never informed otherwise.
That is correct. That is what is contained in his self-serving affidavit. However,
What do you mean a self-serving affidavit? It's his affidavit.
That is correct, but it is.
How are you going to challenge that? Because nobody told him otherwise.
I would submit that it's the defendant's burden to show that there is a due process violation, and the lack of an affidavit from Attorney Sheketoff, who was the defendant's attorney on appeal, would indicate that there was actually a communication.
But can't we infer that Judge Zobel accepted what was in that affidavit when he did what he did?
That is correct. He did accept. It appears that Judge Zobel accepted what was contained in the defendant's affidavit.
That's the end of that. You're out of the picture on that.
What do you think of this idea of counting day for day the time against the sentence? So, as I understand it, we would, assuming he would have, as you concede, he would have been paroled. He would have 4 more years of parole, correct?
That is correct.
What do you think about that?
That would be under the credit for doctrine at time at liberty, the Ninth Circuit doctrine. However, that's only been applied to defendants who have been mistakenly released from prison. This defendant is not in that circumstance.
What do you mean? What do you mean? He was mistakenly free.
Mistakenly released.
I understand what you're saying, but he was mistakenly at liberty.
He was erroneously at liberty, which is different from mistakenly released, where
Right.
This was a lawful release from jail upon a court's order. So
It may be not precisely the same, but the point is, if we're trying to fashion a remedy,
Right.
not every fact situation is going to be the same, but if we're trying to fashion a remedy, why isn't the remedy that Justice Botsford suggested not a reasonable remedy?
Because it's one that acknowledges the argument you're making, which is all you have is simple negligence here, not gross negligence. And that, as I understand it, this day for day is applicable then.
I would state that a case has done what you're talking about, fashioning a remedy, and that's State v. Roberts. It's a Louisiana case from 1990. In that case, the court took into consideration different factors, including the nature of the offenses, the mitigating aspects of the defendant's involvement, the sentences that were imposed, the lapse of time without execution of sentence, the exemplary conduct of the defendants during the time they were at liberty, and the absence of any fault or wrongdoing on the defendant's part. And those are the factors that court took into consideration.
Where would we end up if we went that route? He'd not have to go to prison, but he'd be on parole for 4 years?
In that court, they didn't do it.
No, I'm talking here.
In here, if you did.
If we did that, he would end up where?
If you did the day-for-day credit?
Yeah.
It is unclear, but the defendant would still have 4 years of parole remaining.
Would he go to prison?
Parole or probation?
He would have parole.
Would be
You
parole.
can't really
remaining.
get paroled, I suppose, can you?
You can't. But here's the
Unless you've been
problem.
in jail.
Usually parole is conditioned
That's correct.
upon not violating the law, correct?
Correct.
And he's violated the law, correct?
has violated
So in
the law.
fact, we either decide that he has to serve 4 more years. Even if you do day for day, you've got 4 more years, correct?
It is difficult.
At minimum.
Well, it's unsure whether or not his parole would have been revoked because of his 2 arrests in 1999 and 2001 and his most recent in 2007.
Most likely it would have, because at least in probation revocations, we see constantly they're being revoked when they commit was domestic abuse, wasn't it?
It was domestic abuse against his wife.
Commit crimes like that, and sometimes crimes a heck of a lot less severe.
What were the parole rules in effect in those days for the 20-year Concord sentence? I mean, were you on parole for 20 years once you got paroled? Let's say you did the 2 years on a 20-year Concord sentence. Were you on parole for the next 18 years, or you didn't get good time credit?
That's correct. I'm not sure of the rules. I would assume that he would be on parole for the entire 20 or the
18.
the 18 extra years. But it is the Commonwealth's position that the full sentence is still in effect and valid and should be imposed against,
So he's gotta-
executed at this time.
Thank you, Ms. Valero.
Thank you.
Mr. Flaherty?
May it please the court, I'm honored to be here on behalf of Mr. Lee. My name is Daniel Flaherty. This case is about the defendant's right to fundamental fairness and the due process of law.
Well, it is and it isn't. We've got a victim out there of a very serious crime. It's a rape. And she must know, I assume does know, that this man never served one day, except for the 2 months, one day of his sentence. What do we do about that?
Well, I don't dispute that. I don't dispute the serious nature of that. But in the cases, at least, that I've researched, that issue hasn't arose.
But they really weren't victim cases, were they? A lot of them?
There are some armed robberies in the list of cases. Nothing that would have a victim of this nature, of this significance. That's for sure, Justice Foster. But, Judge, if I suggest to the court that those interests were represented by the government, and the government failed to represent her interests in this case as far as getting the sentence executed, that shouldn't be the defendant's fault now, 16 years later.
Would you, how would you categorize the government's negligence here? Simple, gross?
I would categorize it as gross negligence.
I have to say, to leave somebody who has committed so serious an offense, I take it that the charges against him subsequent to this offense were not additional rapes, correct?
They were not.
But it is not unknown in our judicial system that people who commit one rape commit another. So the fact that you leave a convicted rapist out on the street seems to me to be very serious.
I agree. Added to that,
He lived in the community, as I understand it.
he remained in the community.
Did he stay at the same address for all these years?
He stayed in the same city, Lowell.
Lowell.
I believe he changed address
But he
a
was
couple
always
times.
in Lowell.
He was always in Lowell.
Did he work?
He always worked in the same area, sort of the North Shore area. He changed jobs from time to time, but the same profession. That's the same type of profession he had at the time of the trial. That is, he was sort of a frontline
And
factory
we can
worker.
infer he managed to get hired at these places even after a Corey check was done and they found out he'd been convicted of rape.
That's a fair inference, I
Most people
suppose.
now do Corey checks.
Yes.
So he was there. He was.
So his failure to register as a sex offender was a consequence of his original conviction, correct?
I believe it was. He, in his affidavit, he describes that he got something from the sex offender board and replied to it. Didn't understand the next step he had to take. That is.
But it was
reported
definitely
first.
this offense. I mean, there's no other sexual offense on his record, correct?
Correct. There's no other sex offense on
Does
his
he have
record.
language difficulties?
He does.
Did he
came to
have
this-
an interpreter at trial, if you know, back when the trial occurred? Don't know.
Well, he has
I
an
can't tell
interpreter
from
for
the
your
record if he did.
affidavits, right? He had an interpreter for these affidavits that are in the
He had an interpreter in court. In Massachusetts, there are two Keemer interpreters. We had one in court, not one available in the jails. So I was able to speak with him. I used the interpreter in court. I went to visit him in jail. There wasn't one. We spoke. I'm not 100% sure, confident in our communication, the level of our communication.
You don't
But
speak Keimer, do you?
I
Come here.
don't.
No, but you could get through and make English
you
understandable.
Didn't you actually correct your affidavit after having the benefit of an interpreter?
In court, we used the interpreter to go over the affidavit, and he made some corrections to it. So that's how we communicate. So there is a language.
Mr. Flaherty, I suppose we can, the places that he has worked, to the best of your knowledge, are those enterprises where English is spoken?
My impression is yes. His position was one, as I understand it, it's in his affidavit, was that he was building on a factory line computer boards, that type of thing. So the necessity of him being able to speak English fluently, I don't think was an issue.
No, not fluently, but if one lives somewhere for 16 years and you have to speak English from day to day, your English is going to be better at the end of 16 years than it was at the beginning.
I agree.
In any case, do you know for how long he'd been in the country before he was indicted?
He came to California in 1982, I believe his affidavit says. Then he moved to Virginia for work, and then he came to Massachusetts, I think, in the mid to late 80s.
And he is a citizen.
He actually, I believe it's in the
Record.
Commonwealth submission in the record. during this pendency, during the 16 years, this goes to the prejudice that he's affected by now, he addressed his status. He was allowed to remain after a full-blown hearing before the Immigration Board and the appeals in Virginia under the Convention Against Torture as an alien from Cambodia. Now, he's being held on bail on this case, in addition to what I just learned, a sentence on this new case.
So he's if I could shorthand it, he's a legally protected or recognized alien in this country.
Well, there's a detainer now.
There's a
for him.
detainer now. I think the way it was, the decision ultimately was his deportation was deferred under that convention. That was in, I think the ultimate decision was 2002 or 2003.
So now there's a detainer to get him before the immigration authorities, possibly send him back to Cambodia?
There's a detainer. My conversation with his immigration lawyer was that he's not sure what can happen. Immigration sort of doesn't.
Why would anything likely to happen as a result of that? It's the same case and nothing has changed, other than the fact that he may have to go back.
The world has changed.
I think that's the
Cambodia
answer from Justice
It also
Corey.
could
It's
be
sort
the
of a
sex.
different world.
It also could be as a result of the charge on the sex offender registration, couldn't
Well,
it?
the detainer didn't issue until he was held on bail in this case. He was on personal out of Air District Court. He was handed a summons to go to Superior Court. That's when the DA's office caught on that he hadn't served his
Well,
sentence.
anyway, we can't do anything about the detainer. That's collateral to what
What
we're
do you
doing here.
what do you think? I mean, don't you think that the fact that he committed 2 other crimes in this period of time involving violence against women or a woman, you don't think that should have any bearing on the fairness of this particular issue?
The way I look at it, they're unacceptable. He was convicted of one. I believe it was just one count of assault and battery. The allegations are that there were 2 cases. There were certainly 2 cases.
He
Allegations
paid
are serious.
fines on the other one, correct?
The case was dismissed. He paid fines. That's correct. The significance for this case, I think, is that he was in court in Lowell, in the town they lived, in front of the same prosecutor's office. That is, it raises the level of negligence, that they had a record, they faced him, that he was involved with the police in front of a judge, the
But
probation
it's certainly
department.
not part of the probation record. You'd have to go to the jail. You'd have to go to Concord Prison to find out whether he'd been there or not, wouldn't you?
That's fair. I think that's fair, but I also think that a prosecutor looking at the record may say, hey, he had a 20-year sentence. He's at least on parole. There's something else happening here. I think that would trigger at least that inquiry. I'd note that the DA's office in the 2001 case actually requested certified copies. They were preparing for trial, and there's a letter in my submission that they actually requested the certified copies. So they knew about this case, and they were paying attention to it, at least the existence of it in his past. Whether they knew the outcome, I don't know. His record does say that the case was closed, and that's also in his affidavit. He was told that his case was closed when he was in court. So, but the
And
significance of those cases...
the judge apparently accepted that affidavit?
Judge Zobel accepted
No,
that.
and who told him it was closed? Does it state who told him it was closed?
No. No, that's
Somebody
my
connected
conversation
to
with
the
him.
Chinese something that...
I think that what happened when he was convicted, a Chinese organization, as he calls it, hired a lawyer for him for the appeal. He didn't have much direct contact with him, he said once. But that organization, at least someone from there, told him he was going to be all right or the appeal was all right. And that's where he starts on this line.
Mr. Frey, can I ask you this? The judge ruled, as I read the transcript, that the sentence is deemed served. Well, I mean, I can see how and you make several arguments that the Commonwealth's motion to execute the sentence should be denied because it's been waived, or the Commonwealth should be stopped, or it violates some notion of speedy sentencing. But what's the judge's power to, and there's no revise and revoke here. I'm not even sure Rule 29 would be timely, would it? I mean, at this point. So all he's doing is just deeming it served. What's the power of the court to deem something served like this?
Well, I think the justices have a Superior Court justice has that ability, the control over the sentence, the Articles 11, 29, and 30 to give the independence
Well, I
to the
suppose
judiciary.
if we construe it as a Rule 30 motion, as my brother suggested, I agree with you, there couldn't be a revise and revoke because none was ever filed, and the time limits, according to our cases, are just not changeable. We've been very strict on that. If we treat it as a Rule 30,
Interest of justice.
yes, the interest of justice provision in that could conceivably be relied upon to authorize what the judge did here. That in the interest of justice, it's just not proper to execute this sentence at this point.
If this had not happened the way it did, would he be on parole today?
I don't know. I think that's, I can't determine that. I mean, he would have been eligible for parole after 2 years.
Well, sure he would have
He-
been, unless he went into Concord and did something awful down there, they would have paroled him in the normal course.
But unless he was serving the sentence, I think his two options would either be on parole or still serving that 20
But
years.
if,
sentence would
but if
still
he had
be in
served
effect.
2 years.
Still be in effect.
You mean the length of the parole?
If he violated, then he'd go back in. That's what I think.
I
that's
think the
my
length of
suggestion.
parole is 16 years, isn't it?
18 years
18.
parole? If he got out of
18
jail
years.
after 2 years, if he had served 2 years in jail, would he be, and he behaved, and never got into trouble again, would he have been on parole, or will he have been on parole? Would he have been on parole for 18 years?
My understanding is he'd still be on parole, yes.
Yeah.
Yes, and wouldn't that have been revoked, most likely, based on these domestic violence incidents?
Well, if he was on parole, he would have been in a different condition. That is, he would have been warned that he was on parole. In this case, he was just released. He was just out on the street, and the only thing that he presumably had was this post-conviction probation. If he was on parole, he would have been
Had a parole
advised
officer.
of those obligations. So the past, the future for him back then might have been different. But in addition to the Rule 30, I just say that what Justice Zobel did was protecting those rights. I think it's supported by some of the theories that I try to put in my brief, but certainly under a due process analysis, and perhaps a waiver, and perhaps credit. If there are no other questions, I'll...
Thank you, Mr. Perry.
Thank you.